A Supreme Court decision just hit like a firebomb, and most gun owners still do not understand what changed. Pause. And the scary part is, this was not even a carry permit case, but it started changing carry fights almost immediately. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could keep you from making a mistake that costs you your rights, your money, or even your freedom. Hit that button now. Here's what just happened. The Supreme Court ruled 8-1 in a case called Rahimi. A man under a domestic violence restraining order challenged a federal gun ban. Most people heard that headline and thought, okay, that's about abusers, not me. But that is not the full story, not even close. Because the court did two things at once. First, it said a person found by a court to be a real threat can be disarmed for a time. Second, and this is the part that shocked me, the court also explained how lower courts should think about gun laws after Bruen. If you own guns, carry daily, or even just keep a permit in your wallet, that second part matters to you right now. Let me break this down for you in plain English. Back in 2022, the Supreme Court decided Bruen. That was the case that said regular law-abiding people have a right to carry a handgun in public for self-defense. T also said the government cannot defend a gun law just by saying, well, this law seems useful. The government has to show a real history of similar gun rules in America. So after Bruen, a lot of gun owners thought, great, most carry restrictions are going down. A lot of states thought the opposite. They started rewriting their carry laws fast. They made huge lists of so-called sensitive places. They added new permit rules. Some states even said if private property is open to the public, like a store, you still cannot carry there unless the owner gives clear permission first. Then Rahimi arrived. And here's the crazy part. The court did not back away from Bruen. But it did soften how hard Bruen could hit the government. The justices said the government does not need a perfect historical copy. In other words, a modern gun law does not need an exact twin from 1791 to survive. That single idea matters a lot. Why? Because states and lower courts instantly grabbed onto it. Most people think Rahimi was narrow, and legally it was, but in real life it sent a message. The message was this: the Second Amendment is real, but it is not unlimited. The court said that clearly. So if a state can connect a modern restriction to an older tradition in a close enough way, some judges may uphold it. Now, does that mean your permit is worthless? No. Do not fall for that panic line. Bruen still protects public carry for ordinary self-defense. States still cannot make you prove some special rare reason just to get a permit. That part is huge. That part is still alive. But here's what most people get wrong. Winning the right to carry in public is not the same as winning the right to carry in every place, under every condition, with every kind of rule. That is where carry law gets dangerous. Imagine you have a valid permit. You pass your background check. You do the training. You think you're covered. Then you walk into a private business in a state with a default no carry rule. There's no big sign at the door. Nobody stops you. You assume silence means okay, but under some state laws, silence can mean the opposite. That is where ordinary people can get trapped. And Rahimi gave lower courts more room to say, maybe some of these modern location rules fit our history closely enough. That is why this 8-1 decision hit carry rules instantly, even though the facts of the case were different. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Now let's talk about where this gets very real for you. First thing, New York. After Bruen, New York passed a law called the Concealed Carry Improvement Act. That law added a pile of new carry restrictions. There were fights over sensitive places, permit rules, and private property open to the public. A major challenge went up through the courts in a case called Antoniuk. Here is the important part. After Rahimi, the Supreme Court sent an earlier version of that New York fight back for another look. That alone told everyone that Rahimi was now part of the playbook. Later, in 2025, the Supreme Court declined to fully step in and blow up the whole New York law. So most of New York's carry restrictions stayed in place while the case continued, except for a couple of pieces that remained blocked. Read that again in your mind. Bruen did not erase every carry restriction. Rahimi did not erase Bruen. Instead, courts started sorting rules into buckets. Some rules may still die, some may survive. And your state matters a lot. Second thing, and this is where it gets interesting, Hawaii. Right now, one of the biggest carry cases in America is a challenge to Hawaii's law on carrying guns onto private property open to the public. Think stores, shops, and other businesses. Hawaii's rule says you need express permission from the owner to carry there. Why is that such a big deal? Because if that rule stands, public carry can shrink in real life even if your permit is technically valid. You can have the right on paper but lose it the moment you step onto most private property open to the public. That means the right exists, but only in tiny slices of daily life. Have you ever wondered why so many post-Bruen gunfights are about places instead of permits? This is why. States know they may not be able to stop permits the old way. So instead, they can limit where you may carry after you get one. And when the Supreme Court heard arguments in the Hawaii case, some justices sounded skeptical of Hawaii's rule. They pushed hard on the idea that the Second Amendment should not be treated like a second-class right. That sounds promising for gun owners. But wait, there's something even more important. As of right now, the court has not issued the final decision yet. That means the rules could shift again by the end of June 2026. Here's a hypothetical example to explain this. Now, let's say you have a valid concealed carry permit. You leave home armed, you stop for gas, then you grab a drink inside, then you run into a small market, then you pick up dinner. If your state uses a broad private property rule, that normal afternoon can turn into a legal minefield. Not because you are a criminal, not because your permit expired, but because the law may treat every one of those places differently. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Let me say something else that nobody's talking about enough. A lot of gun owners still think federal gun law and state carry law are the same thing. They are not. Federal law can decide who may possess a gun at all. State law often decides where, when, and how you may carry it. So when a Supreme Court case changes the way judges think about the Second Amendment, both levels can move. This is why headlines can fool you. One case is about a restraining order. Another case is about private property. Another is about sensitive places. But underneath all of them is one giant question. How much room does the government have to limit carry after Bruen? Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who get these updates first. Click subscribe, because these court fights move faster than most news channels can explain them. So what should you do with all this? I'm going to give you 3 simple rules. First, know the difference between being allowed to own a gun and being allowed to carry it in a specific place. Those are not the same question. Rahimi dealt with possession by a person under a restraining order. Bruen dealt with public carry rights. New York and Hawaii are fighting over where carry may happen. Different questions, different traps. Second, stop assuming your permit travels safely through every door. This is the mistake that burns people. A permit is not a magic shield. In some states, schools are off limits. Government buildings are off limits. Polling places may be off limits. Places serving alcohol may be off limits. Public events may be off limits. Parks, beaches, trains, hospitals, and private businesses may have their own rules depending on the state. Most people think, if there's no metal detector and no sign, I'm probably fine. The truth is, that guess can go very bad. Third, check your state law every time a major court ruling drops. I know that sounds annoying, I know it feels unfair, but this is the real world now. After Bruen, states rewrote laws. After Rahimi, courts got new guidance, and after the coming Hawaii ruling, we may get another major shift on private property carry. Let me give you a traffic stop example, because this is where people freeze. Imagine you are driving home. You have a lawful firearm in the car. The officer asks if you are carrying. Your answer matters. Your state's duty to inform rule matters. Where the gun is stored matters. Whether you just came from a restricted location matters. One bad assumption can turn a normal stop into a criminal case. And here's the part that really bothers me. A lot of these cases are not about hardened criminals. They are about regular people trying to follow rules that keep changing. That is why you need to think like a lawyer before you act like a gun owner. Another warning. Do not confuse online hype with actual law. I keep seeing people say, the Supreme Court killed all carry bans. False. Others say, your permit means nothing now. Also false. The real answer is more frustrating. Your core right to public carry for self-defense still exists, but the fight has moved to the edges, the conditions, and the places. That means the next big losses or wins will probably happen in those edge cases. Private property open to the public, sensitive places, permit conditions, vehicle storage, public transit, event zones, distance rules around protests. The boring details are where people lose. And when I found that out, I couldn't believe how many gun owners were still only watching headline clips. This information could change again by June 2026 when the court rules on the Hawaii case. Subscribe now because my next video explains exactly what you should check before you carry into any business, parking lot, or public-facing private property. So here's the bottom line. The Supreme Court's 8-1 Rahimi ruling did not cancel Bruen, and it did not erase your right to carry for self-defense. But it did give lower courts a new way to uphold some gun restrictions, and that hit carry rules fast in places like New York and in the fight now happening out of Hawaii. Pause. Your biggest risk is not just bad intent, it is bad information. So stay sharp, stay current, and never assume yesterday's rule is still safe today. If this helped you, subscribe right now and send this video to one friend who carries and thinks a permit solves everything. It doesn't. Laws change, court rulings stack up, and one misunderstanding can cost you more than you ever planned to lose. And one last simple disclaimer. I'm here to educate, not to give you personal legal advice. Always check your state's current law and talk to a qualified attorney if you need advice about your exact situation.